President Trump was just handed a trio of setbacks in court. On Friday, a judge blocked, for now, Trump's controversial $1.8 billion anti-weaponization fund from moving forward. The same day, another judge ordered Trump to respond to accusations that his unprecedented settlement with the IRS, which led to the creation of the anti-weaponization fund, was fraudulent and, quote, premised on deception. Hours later, a D.C. district judge ordered Trump's name removed from the historic Kennedy Center, declaring Congress gave the center its name and only Congress can change it. And Trump took to social media after the ruling and said he would cease his involvement in the building's renovations and return control to Congress. Now, the Justice Department has launched a criminal investigation into E. Jean Carroll, the former columnist who accused President Trump of sexual assault. Now, multiple sources tell CNN the Justice Department is focused on whether Carroll committed perjury during one of her depositions when she testified that her lawsuits were not funded by outside sources. Her lawyers later told the court that, in fact, a nonprofit tied to billionaire Reid Hoffman had helped cover some of her fees and legal expenses. Carroll was awarded $5 million in 2023 after a jury found Trump liable for sexual abuse and defamation. She was later awarded $83 million in a second defamation case against him. For more perspective, I'm joined now by former federal prosecutor Neama Rahmani. Now, Neama, I want to ask you, this statement that we're talking about with Carroll saying that she didn't receive any outside funding, this was litigated quite a bit before the civil trial. It was litigated again during appeals. Given that this has already been covered so often in the civil context, what does that tell you about whether they will be able to build a criminal case on the same issue?
Paula, it's hard to get a conviction for perjury in a state or federal court. And here we're talking about a statement during a deposition from 2022. And the reason it's hard is that the statement has to be intentionally false. It can't be just a negligent misrepresentation. And it has to be material. That means it has to be important to the case. It's pretty rare for you to see a federal criminal prosecution related to a statement made in a federal civil case. But obviously, this is no ordinary case. It's involving the president of the United States, the most powerful man in the world. So that's why we're seeing the DOJ look into his political enemies.
So the U.S. attorney said in a statement that the Northern District of Illinois has not opened and has never opened a criminal investigation into E. Jean Carroll. Look, I was part of the team that broke this story. I can say we never said that he opened it, but we do know he is currently overseeing this. Our sources reaffirmed to us that this investigation is into E. Jean Carroll. It is in its early stages, but it's active and ongoing. How common is it for cases to be sent to a different office?
It's not that common. In this particular case, Todd Blanche had to recuse himself as the acting attorney general because he was involved in the litigation involving Jean Carroll. Sometimes what you will see is for a district that may have a more favorable jury pool or potentially more favorable judges to handle an investigation. But it is not common to have this parallel criminal investigation ongoing while the civil appeal is still working its way through the Supreme Court. The president has a number of arguments on appeal, one of which relates to this litigation funding issue. There's the Access Hollywood tape. There's some other woman who testified. Of course, he's still claiming presidential immunity. There's the Westfall Act. So there's a lot that's still being litigated in this particular case. And to initiate a criminal prosecution, obviously, we do have that 5-year statute of limitations. So I think that's probably why we're starting now, is not common. And it's not common for it to be in another judicial district, Paula.
And the president has been very open about his desire to seek retribution against his perceived political enemies. But we've seen lately with the Justice Department's efforts to pursue that, grand jury fatigue on some of these cases. Do you think that grand juries can see through political motivation, or do you think these cases are just sort of failing on the facts, or both?
Well, I think it's both. They're weak on the facts and the law. I mean, it's very rare for a grand jury to return a no bill. I mean, you can count on one hand the number of times that happens in any given year. But we are seeing that more and more. In cases like Letitia James, for instance. Frankly, I was very surprised that the DOJ was able to get an indictment from the grand jury on the 8647 case, probably one of the weakest cases ever brought by the DOJ. But you're right. I mean, if this case actually makes it past the grand jury, I would be very surprised if it got past a motion to dismiss and a trial jury, because there are a lot of defenses here. We talked about some of them: intent, materiality, but also there's a pretty strong vindictive prosecution argument here that the president is going after someone who has filed 2 civil lawsuits and received 2 civil judgments against them, and that's the only reason the DOJ has initiated this prosecution. I think that type of argument would resonate with any district judge in this country.
Neama Rahmani, thank you.
Thanks, Paula. Talk soon.